Good evening, everybody.
Good evening, sir.
Good evening, sir.
Today's topic is Lok Adalat. What is meant by Lok Adalat? Now, whether Lok Adalats are introduced by the judiciary under the provision of Legal Service Authorities Act 1987, the Lok Adalats are formed under Section 19 of the said Act. Please note down Legal Service Authorities Act 1987, introduced by the Union government, and under Section 19, the Lok Adalats are formed and made organized to conduct the Lok Adalats between the parties who are litigant before the court. Now, the preamble is this. In CPC 1908, the section 89 has been introduced. Under section 89 deals with settlement of dispute by way of arbitration, conciliation, judicial settlement, including Lok Adalat awards, and mediation centers. These are the settlement has been introduced in CPC at section 89. Based on this, whether the Lok Adalat to be conducted forever in the judiciary system. Therefore, the Legal Service Authorities Act 1987 has been introduced. So under that act, what is meant by the Lok Adalat that has been formulated under section 19 of the act. Now, whether the Lok Adalat conduct only the trial court or district court or taluk courts or high courts or district courts. So likewise, these centers are formed under the provision of the said act, that is called as Supreme Court Authority has introduced the Lok Adalat, and the senior most justices were appointed as a director of the Supreme Court Legal Service Authority, under whom they have to conduct the Lok Adalat. Likewise, the state authorities are formed, the mediation centers of every taluka or every district or every state. That state is also forming the role of getting the Lok Adalats by way of mediation centers formed with sitting district judge is the director for the said mediation center, and taluka wise also the principal judge is having right to hold mediation center at taluka level. The same thing in High Court is also senior most justices were appointed as a director for legal service authorities. Likewise, there are mediation centers were opened, and at Bangalore, especially Bangalore Mediation Center, that is situated at Nyaya Devula building at Siddhaya Road, where the family courts are situated. That is the ground floor building has been taken for the purpose of conducting the mediation center, that is Bangalore Mediation Center or BMC, used to matter going to be referred. So, which are cases going to be referred? Whether the pending cases were alone going to be referred to the Lok Adalat or not. That is one thing. And there are wing has been formed receiving the complaints between the parties and they want to refer the matter before the Lok Adalat or mediation center, they are also making an application before the Lok Adalat authorities. So likewise, BMC authorities are conducting very seriously and several matters are decided based on the compromise or advisor of mediators who are having experience of 15 years in service in the court, those who are conducted civil matters as well as the criminal matters, they are eligible for the conducting the mediation center. So likewise, several mediators were appointed, the senior advocates who are going to card as mediator, and upon which as per the section 89, the matter will be referred either before the arbitration or before the conciliation or before the Lok Adalat or before the mediation centers. So under section 89, he is having power to refer the matter, those matters which are easily available for settling the dispute between the parties. Therefore, section 89 is compulsorily using by our judges from all the courts of India. They are referring the matter, mediation center or arbitration or conciliation or Lok Adalats. So now the question is this: the compromise between the parties is not forcible compromise. It cannot be fraud or misrepresentative or entitled to be compromise the matter. The BMC, that is Bangalore Mediation Center, going to draw the agreement through the mediator. After both parties are convinced and certain conditions wants to put in the agreement. So therefore, before the mediation center, the agreement going to be drawn. After drawing the agreement, it will be referred back to the court. Court, based on the parties are agreed upon the said agreement, going to pass the award that is called as Lok Adalat award. Such being the case, whether that award can be questioned in any court, no, that is final. Once the agreement was drawn by the mediation center, accepted by the court, and decree has been drawn, it is final. And no decree, no award questionable before any court of law. That is the law decided by the Honorable Supreme Court. So therefore, any cases pending before the court, those cases can be referred to the Lok Adalat or mediation center conducted by the court. So formerly what happened, our Honorable Supreme Court Justice, Chief Justice used to fix the Lok Adalat every month. That is called as on second Saturday especially. So therefore we are also participated, the advocate and parties, they can sit together and discuss about the compromise or pursue to the compromise matter why the litigation should be continued. Based on both advocates placing their report or placing their addressing the matter before the mediator, then they are going to conduct single, means if the plaintiff or petitioner come before the mediation center, they want to clarify by calling them single, and they later another fellow they are calling, conducting and holding the meetings. So likewise, the several matters are going to be settled. So the same thing is at Bangalore. During my practice, so many cases, legal service authorities were referred the matter under section 89. Gladly we have conducted so many cases and compromise. We are trying to pacify the dispute between the parties. So therefore, automatically the agreement going to be drawn under section 24 of the Legal Service Authority Act. That is the called as award. That is called as award. And that award, which is accepted by the court, it is final. So section 4, automatically, it is final judgment. There is no appeal. It must be noted down under section 20, whatever award has been passed under section 20 of Legal Service Authorities Act before the Lok Adalat or before the mediation center or under section, this is CPC 96.3, 96.3, please note down, because always it is referable matter before those who are practicing in civil side. No appeal shall lie from the decree passed by the court with the consent of party. So 96.3, when the decree or award, consent of the party, compromise application has been made, it cannot be questioned. So therefore, no appeal shall be laid against the judgment and decree passed by the court on acceptance of the party or on compromise of the parties. So now, what are the questions before you? Sir, you may ask whether the offenses, criminal cases going to be, yes, those cases which are cognizable in nature and the mediation center can be entertained those cases within 3 years of punishment that can be settled between the parties before the mediation center. And what about the punishment is more than that? So especially section 498A, it cannot be compromised in the local law, but they have to question that FIR or charge sheet before Honorable High Court of Karnataka under section 482 to quash the proceeding. Then the Lok Adalat will be referred and matter going to be compromised between husband and wife. So therefore, that proceeding can be quashed only by the High Court, not by before the Lok Adalat. Likewise, based on the offences which are punishable under section punishable within 3 years of imprisonment, those cases compoundable in nature under section 320 of CRPC, those cases can be referred by the magistrate. So likewise, 96.3, it is role 96.3 of the CPC. It is the case award passed on the agreement, no appeal lies. Now, yes, where should we go for that? Then in the year 1977, the CPC was amended. Then one section has been introduced, section 23A. If the compromise decree misused, misrepresented, or fraud has been taken place, they have to file the application before the same court under section 23A of under order 23A, under order 23A. So therefore, capital A introduced in the year 1977, because 1998 that provision is not available. If any order passed in the compromise decree, separate suit cannot be filed. Now always you see, if any decree has been passed based on the compromise, we used to file suits. The compromise decree is not binding on us. So that suit is not maintainable before the court. There are several judgments already passed. So therefore, kindly maybe be remember, the compromise decree passed before the court, that cannot be questioned in by way of separate suit. Therefore, under order 23, capital A has been introduced in the year 1977 in the CPC. The suit is bar not to file a suit questioning the compromise decree If they want to any misrepresentation or fraud, they can file application before the same court and they have to apply under miscellaneous proceeding before the same court. But not, they should not question by way of filing separate suit. Please bear the mind under order 23 capital A, wherever the compromise was took place, either in Lok Adalat or in mediation, those questions cannot be brought before the court by way of filing the suit. That is under section 23A, it is bar to file a separate suit. Now, the decision is concerned whether the Lok Adalat award passed in the Lok Adalat by way of agreement, accepted, award has been passed. So that award can be questioned whether or not. That is the one judgment. Kindly maybe note down AIR 2005 SC 3575. Now, wherever the compromise was took place, wherever the fraud has been noted down, or wherever the misrepresentation has been made, or wherever the parties are not to the compromise decree, who are not filed a suit, who are not parties to the said agreement, then they have to file only by way of writ petition, not by way of suit or anything. So therefore, please note down AIR 2005 SC 3575 PT Thomas versus Thomas Job. This is the decision. Every compromise decree before the Lok Adalat, it cannot be questioned and it cannot be taken into consideration before the court. Even they cannot file miscellaneous petition. That is para number 22 of the said judgment. 25 is declared as award. It is a decree. Now recent judgment. Now yesterday I have gone through the one judgment. Honorable Supreme Court remanded the matter. Kindly maybe look into AIR 2022 SC 2381 Srinivasappa versus M. Mallana. From High Court, what it happened? This matter was decided before the Lok Adalat. Then some of the petitioner and respondent, they have questioned the matter before Honorable Supreme Court because the misrepresentation and fraud was taken place while compromising before the Lok Adalat. Therefore, that judgment shall be set aside. Then matter has been remanded to the High Court because the writ jurisdiction is having, which was decided in the year 2000 P.T. Thomas case. Therefore, matter has been remanded. The opinion shall be formed by the High Court stating that there is a fraud or misrepresentation took place or not. So therefore, AIR 2022 SC 2381. Kindly maybe look into that topic, that matter. It is very necessary for you. Tomorrow you can decide. So whether these cases are referred for the Lok Adalat award, where we should go, then only the writ lies before the Honorable High Court of Karnataka, not for any other courts, because it is bar under 96, section 96(3) of CPC. So likewise, it is also bar under order 23A, capital A of the CPC. So this is the matter I want to introduce to you. Any matter can be referred before the Lok Adalat, and those matter through legal service authority or through the court section 89. If the matter is referred before Lok Adalat, and that shall be decided finally between the parties only without force, without coercion, without any threat, both parties on the advice of mediator with presence of the advocates. So this automatically the mediation, if you want, you go to the mediation center and you get the permission from the director of the mediation center, participate in the proceeding at Nyaya Devula building, where at ground floor it is situated. So kindly maybe look into and you attend the proceeding. Yes, is there any question for this? Up.
Start madla. If there are no questions, I will start with legal opinion.
Yes,
Sir,
sir,
I have a
please.
doubt.
Yes, madam.
Sir, if regarding if there is any suit or anything, just the first itself we can approach the Lok Adalat and we can get the decision there, sir. Without
No, single
filing
cannot
suit.
be allowed until and unless both parties are appeared and both parties they want to refer the matter before Lok Adalat through Legal Service Authority, through Taluka Legal Service Authority or BMC, Bangalore Mediation Center, Legal Service Authority, only the matter can be referred, or otherwise any pending cases. The only two
Okay.
mode of referring the matter before the Lok Adalat.
But before case has to be filed by one of the parties before
No,
approaching Lok
the
Adalat.
filing or not, that is
Yeah,
not
filing.
the. Yes, ma'am.
It has to be filed in the court, sir. First, it has
Yes,
to be
yes,
filed in the court.
yes.
Okay, sir. And according to the seniority only, it will we can from the legal service authority they
No,
take it or
madam, no mediators, several mediators were appointed. Your matter can be expeditiously, it can be done within 2 months, because 3 sitting they are providing, 3 or 4 sitting. If the mediator
Okay.
are advising, or advocates are advising, or if you both come together compromising, immediately on the same day it can be done.
Okay, sir. But both should be willing. If the other party is not willing, we cannot do it, sir.
No. It is going to be referred back, and always the report only not settled. That's all. And whatever discussion took place, this is bear in mind, whatever discussion took place before the local or mediation center, it won't communicate by the mediator or anybody else.
Cannot be used as evidence.
And it cannot be used as evidence for before the court.
Okay, sir.
Right.
Okay. Okay. Thank you, sir.
Welcome, madam. And now next, another topic is going to be conducted, Mr. Abhilash. You please note down all these things, and we remember P.T. Thomas case and Srinivasappa's case. These two cases are remarkable decision of Honorable Supreme Court given. Lok Adalat award cannot be questioned. At para number 22, no appeal lies, and if they want to question only the fraud or misrepresentation, only the High Court they have to question. And another suit cannot be filed under Order 23, capital A of CPC. No suit is maintainable, or you cannot recall the compromise which is took place on filing of the application under Order 23, Rule 3. So it cannot be questioned. So therefore it is barred under the civil suit. Thank you.
Thank you, sir.
Welcome.
We'll start in 2 minutes.
Thank